Namaskar, I am Assistant Professor Kritika Dev from LJ School of Law, and today we'll be studying again a very important and interesting topic, that is assault against women. Now, the sections that we are going to read today have come into existence after the Criminal Law Amendment Act 2013. So, today let's study these amendments in detail. So, the sections after amendments which came into existence are section 354A, 354B, 354C and section 354D. Before this very session or before this very lecture, we had a lecture on section 354, outraging the modesty of a woman. Now this you can say is an extended version which came after the amendment 2013. Now let's see the background of that amendment. Now, we all know the reason why this very sections or why number of sections had been included under many of the acts. It was because of the Nirbhaya case. Yes, the very one of the darkest day of the history when this very case took place, and of course, it helped these sections to come into force. Now, this very amendment, it had brought many changes in many of the acts, like our Indian Penal Code 1816, Indian Evidence Act, Criminal Procedure Code, Sexual Crimes Against Children, that is POCSO. So it had brought many amendments in some of these sections as the subclauses or maybe as altogether a different section. So today, let's see the amendments which have been made under section 354 of Indian Penal Code. But before that, it is very important that we know that since when this criminal act came into force. It came into force from 3rd February 2013. Yes, this was the date from which this amendment came into force. And as we have seen that it had made amendments in these of the acts that you can see on your screen. Now, let's move on to the next slide. What are the basic features of the act? Now, when it comes to the amendment, it made certain amendments by keeping in mind the a large section of the society, that is of course women, and it made changes in section relating to sexual offences against female, criminalizing acid attacks, which we will discuss under the heading previous heard, section 326A, section 326B, which talks about criminalizing the acid attacks and giving a very specific punishment for the offense, and then penalizing human trafficking as well. So these are the headings under which this act made many amendments. Of course, even before the amendments under section 354, there had been certain guidelines on sexual harassment cases. Now, the base of those guidelines were the Vishakha case. By the case, the court gave certain guidelines on which the case used to commence and the justice used to be given. But of course, with time, a need was felt that some specific sections has to be there in the act in order to give proper justice to the victim. So, by the guidelines of Vishakha versus State of Rajasthan, AIR 1997 SC 3011, the guidelines used to be followed in dealing with harassment at workplaces. So it was, you can say, it was a bit limited to sexual harassment at workplaces, but the amendments that we are going to see covers a wide, or it has a very wide perspective. Now, let's move on to the next slide, which talks about section 354A of Indian Penal Code. Till now, we are much aware of the background, that why there was a need of the amendment and the things which are being covered under the amendment. Different acts have been amended, and different topics or different offences had been amended. But today we are just focusing on section 354A, B, C and D. Now let's see what section 354A says. It talks about the sexual harassment and punishment for sexual harassment. Now, a man is set to commit this offense if he does any of the following acts. Firstly, physical contact and advances involving unwelcome and explicit sexual overtures. Now, I guess this is very simple to understand, but if he tries, let me give an example, that if he tries to have a physical contact, or the man has this physical contact and advances involving unwelcome and explicit sexual overtures, then he will be booked under this very section. Any demand or request for the sexual favors. Now, it could either be a demand or a request. Sometimes a man generally he asks in a very requesting tone about the sexual favors. So keep in mind it could either be a demand or a request. So it could even be on a high tone that yes, I want this from you, or it could even be a request that if you do this, or if you entertain these sexual favors, then you might at the workplaces we can just take an example that you might get promotion. So it could even be at a requesting form or on a demanding form. Showing pornography against the will of a woman. Now if any man forces a woman to see a pornography, then also he will be charged under this very section and he will be punished under this section. Now the fourth point is making sexually colored remarks. Now sexually colored remarks is any remark, any saying or any remark on a woman which derogates her integrity, which harms her integrity, which harms her reputation or the modesty, you can say. Right? So even if he makes any of these sexually colored remarks at the public places, at private, doesn't matter, but if he does so, then he'll be guilty under this very section. Now, as we have seen those four types of acts, those can be either committed in public or private. That does not matter, right? If a man is just asking some women for the sexual favors in private and then he says that nobody heard, it was just between me and her. No, that will not be a defense because it can be, of course, uh, 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 done or said in private or in public in front of people, right? So, any of these four acts, if any man commits any of these four acts, then he will be charged under section 354A. Now here in this slide, you can see that the punishment have been divided into categories. Now what are these two categories? Coming to clause 1, 2 and 3, right? They have been put together, and if a man commits any of these three crimes which have been mentioned under 1, 2 and 3 clause of section 354A, then the punishment would be rigorous imprisonment up to 3 years. See, as I said, whenever there is, it may extend to, right? In order to make it simple, I have written up to, right? Up to means that is the maximum punishment. Here, 3 years is the maximum punishment. The lower can be 1 month also, right? Could be couple of days also. So here we can see the least punishment is not being defined, only the maximum punishment is being defined, that is 3 years, or fine, or both. So here fine is again an option, or it could only be fine and no imprisonment, or both. So fine with imprisonment is not compulsory, or imprisonment with fine is not compulsory, because we can see that or is written here. So this is very important for the students to keep a note of it, where or is written or and is written. Coming to clause 4. Clause 4 talked about sexually colored remarks. So when anybody gives those sexually colored remarks, then the imprisonment is up to 1 year. Again, the term up to is being used. It means the maximum punishment is 1 year. Minimum can go to any number of days or months. That is completely up to the discretion of the court. Or fine, or with both. Again, or is being used. So any of these two or both can be given for section 354A. So 1, 2, 3 clauses have a different punishment. Clause 4 has a different punishment. Okay, let's move on to the Next offense, which has been defined under section 354B of Indian Penal Code. Let's quickly read the section. It says, assault or use of criminal force to women with intent to disrobe. Right? Now, any man who assaults or uses criminal force to any woman or abates such act with the intention of disrobing or compelling her to be naked. Now, this section is all about disrobing a woman or, of course, trying to be or to make her to be naked. So here, again, there are two elements. It could be done through assault or criminal force. And now, if a person is doing this act, he can do it through abatement, right? It means he may ask somebody else to do it. For say there are a number of men standing, and the head of those group of men says that you just go and disturb that woman, or you try to compel her to be naked. So this is how he's abating the crime, or in any other way. Coming to compelling her to be naked, it could be even done in that way that he's not touching that woman in any way, but posing a threat by saying that if you do not get naked, I'll kill your child, or if you do not roam naked in the whole village, I will beat your father, I'll beat your brother, I'll beat your husband. So this shows a compulsion. It could be compelling either by touching or by posing any threat to the woman in order to make her naked, in order to disrobe her. Now, what is the punishment given for this very offense? Imprisonment 3 years to 7 years. So here, as we have seen, the punishment 3 years to 7 years. So I have not used the exact language which is there in the section in order to make it simplify, or in order to make it simple for you people to understand. So here 3 means 3 is the least punishment which has to be given. So minimum punishment is being defined, that below 3 years a punishment cannot be given. The court cannot use their discretionary power in order to give punishment less than 3 years. So 3 years is the minimum punishment which should be given, which shall be given, but which may extend to 7 years. So here minimum punishment is 3 years and the maximum punishment is 7 years. Now again, as I said, it is very important to see and is written here and not or, which means that fine is compulsory here, not an option. So when it comes to imprisonment, also fine shall be given, or the accused is liable for fine as well. So these are two combined offenses, or you can say combined punishments. Now let's move on to the very next offense, or very next section, 354C of Indian Penal Code, voyeurism. Now what is voyeurism? Do you have any idea about what voyeurism is? Have you heard this very term before? Now let me give you an example. You must have seen many movies where a person comes and tries to see something out of that keyhole, or out of any of the window, what a female is doing, right? If she's changing a costume, if she's in any of her private acts, or if she's taking bath, whatever is happening, but a man just goes and try to see something from that window or from that very hole. Now this very act of that man is known as voyeurism. Now let's see the definition. Now, as I said, looking from that very small hole or that window and trying to see what that woman is doing, of course. Now, what that woman is doing, we'll see under this very section, that if he sees any of those acts, then only it will amount to voyeurism. Any man who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed, either by the perpetrator or by any other person at the behest of the perpetrator, or disseminates such image, shall be punished. Now here, as you can simply see, that either the person is watching or trying to capture some image. Now, of course, that would be a bit dramatic, but let me give an example. You all must have seen Drishyam. Now, there, the guy captured the video. The guy made a whole video. Now, that amounted to voyeurism. That very boy should have been charged under this section, but yes, he was given the punishment, whatever the movie said. But that amounted to voyeurism because he captured an image, also consists of and video. Image does not mean just a photograph, and if a person has made the video, then he'll be like, or he can say that he is not been covered under the section. But image also means a video. So whether he's watching or capturing any image. Now, the image is any private act of that female, right? Whether she's been or she's expecting that nobody will see her. She is under the impression that this is my private act and nobody should see her. Now, that private act could be anything. Maybe she's changing her clothes, maybe she's taking bath, or maybe she's engaged in any of the private acts with her partner. So, any of these acts where she is under that impression that nobody is watching her, right? And she's in her private space. And then somebody watches or captures the image of that woman, makes a video, then that he will be charged under section 354C. Now, on first conviction, here there are two headings, first conviction and second conviction. On the first conviction, he'll be the imprisonment 1 year to 3 years. It means minimum 1 year, maximum 3 years, and shall also be liable to fine. Again, and is there, so both the punishment will be given. Coming to the second conviction, imprisonment 3 to 7 years. Yes, which means minimum 3 years and maximum 7 years, and shall also be liable to fine. Now here, the next section is stalking. So before reading this very definition, I would just like to give you one example. Now, for say, if there is a woman standing at the bus stop and there she finds a man standing trying to talk to her again and again. And repeatedly, she gave that indication that she's not interested for that conversation, or she generally sees a man trying to follow her repeatedly and trying to just question something, or just trying to follow her, or just trying to make attempts in order to have an interaction, and she's repeatedly seeing or saying no for it, or she's repeatedly showing disinterest. Now, here, disinterest could be by words or even by gesture. That if a man is coming, she's just turning around, or she's just changing her direction. Now, that is disinterest, which is shown by gesture. So, disinterest could be shown by gesture or could be shown by words, that she's not interested in having a personal interaction. Now, if a man does so repeatedly, then it will be known as stalking. Why the term repeatedly is being written? Because if that thing is being done only once, then that would not amount to stalking. If a man just comes to a woman and just asks once, "Ma'am, can you talk to me?" or anything, and if she says no, and if he does not commit that act again, that it will not amount to stalking. The stalking can also be committed through internet. We can say if somebody is monitors any use of email, electronic communication, then also it will amount to stalking. So I guess this section is easy to understand. Now the punishment for, of course, before punishment, we need to see if there is a exception to it or a proviso that if a man who's been uh, doing or who's been committing stalking or who's been following or trying to talk in order to prevent or detect a crime, then it would not amount to stalking. For say, any of the policemen, any of the person who's involved in preventing or detecting a crime, and if he does so, the acts that we have seen, then it will not amount to stalking. And of course, in the particular circumstances, such conduct was reasonable and justified. Now, even if the whole scenario is taking place and if it was not required for him under that investigation to commit stalking, then he will not be protected. But only when the conduct was reasonable and justified, then only the man will be protected under this very section. Now, I hope the definition of stalking got clear. Now let's quickly See the punishment. Again, first conviction up to 3 years and fine. Maximum punishment in 3 years with fine, and on the second conviction, imprisonment up to 5 years and shall also be liable to fine.